Court does call the case. The people of State of Michigan versus Porche Murray.
Your Honor, good afternoon, Jonathan Evans on behalf of the people.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Stan Bernstein with on behalf of Ms. Murray, who is present.
All right, thank you. All right. This is a continuation of the preliminary examination. Are we ready to proceed?
Yes, Your Honor.
All right.
Here, Dr. Hashian was the last witness. He's the testimony that will continue. So
Yes.
I believe
Please come forward and be sworn.
Take a seat, raise your right hand. You solemnly swear and affirm the testimony you're about to give to give the whole truth and nothing but the truth that will be done. See, state and spell your first and last name for the record.
Randy Pashan, Pashan.
You may inquire.
Thank you, Your Honor. And thank you, Doctor, for the continuation. Going back to your autopsy, your post-mortem examination report has a section listed how injury occurred. And again, if you need a copy, just let us know. We all okay. I can. You guys have like multiple copies, or like?
What are you referring to, the autopsy report?
Your Honor, I'm referring to, it's like the middle of the first page. There's a section. It's called
The
how.
post-mortem examination report is the document, though.
Yes, Your Honor. Okay, appreciate it. Doctor, under that section of how injury occurred, list the descendant sustained non-accidental blunt trauma to the head and was subsequently denied medical care. It's the denial of medical care that I want to ask you a couple of questions about. Could you explain how did the denial of medical care relate to the death of the child?
So someone who had these sorts of injuries, whatever, exhibited signs and symptoms of a traumatic brain injury. And so had the decedent been given medical care appropriately, then he or she might have not succumbed to it.
Okay. So you think that if medical care had been provided, then the injuries may not have been fatal?
Can't say 100% for sure, but it would have improved the chances of survival.
Okay. There's no way you could like put a percentage on it? Okay. But it's fair to say that you do think it was a contributing factor overall then?
Which part, the denial of
Yes.
care? Sure.
As a part of your final diagnoses, just below that, one of them lists moderate cerebral edema. And I think that's fancy language for swelling of the brain.
Yes.
Could you explain what you meant by moderate?
It's more of a subjective kind of an assessment of the brain that essentially is based on how much swelling that I can see with the naked eye.
Okay. So on a scale of like 1 to 10, 10 being the highest, and I know it's subjective, are we talking like the middle of that scale?
Yeah, I would say, moderate would be somewhere between mild and severe. So.
Okay. The subdural hemorrhages that you saw, they were, those were things that you could see in the blocks that you looked at, like the slides?
I saw them in the slide, but I also saw them without the slide. I saw them as I opened up the skull.
Okay, it's something that you could see when you lifted them up. Are you able to pinpoint for me which microscopic slides of those blocks that would show those hemorrhages?
I have to refer back.
Please, yep, of course.
Blocks. I have to review the blocks to be able to say that for sure.
Okay. But you think it would be most easily seen in 826?
Yes, I actually described and listed that block as I can read it all.
I'm sorry. If you could just refer to the page number.
I only gave 11.
Can it be easily seen in that block, or does it take a lot of inspection of that one? Well, going back to the last time we spoke, I think you had looked at the blocks a couple of different times. Is the subdural hemorrhage in that block something that you could identify easily, or did it take a couple of passes at it?
Well, I mean, the fact that I described it the way it did means that I was able to see it with my naked eye.
Okay. Okay, thank you. Part of your postmortem report states that there's evidence of, quote, systemic underlying infection. Could you tell me what the evidence of that systemic underlying infection was?
So I've listed here in part for this final diagnosis section, a number of findings that would be this findings that would support systemic infection.
Could I ask what makes it systemic?
So it wasn't a localized infection. So when I talk about localized infection, I would say, you know, there's an abscess on the right arm, for example, and that was it. But in this case, there were multiple areas or multiple systems, multiple tissues that were involved.
Okay, where all in the body could you see the infection?
So there were definitely abscesses microscopically in the soft tissues, skin, or I guess in the skin, soft tissues, and in the muscle in the buttocks. So those would be one finding. Then there were other findings like fluid in some of the body cavities, which tended to be turbid or cloudy, which is another indicator. And then the urine was brown and cloudy as well. So that was suggestive of an infection of the bladder.
Okay. We'll break some of that down, but could you tell how long the infection had been present for? Is that something you're able to determine?
No, not really.
All right. Would the underlying systemic infection contribute to the cause of death?
It contributed to the overall kind of picture. So the cause of death was blunt head trauma. Then these are all kind of associated findings.
Could you tell me how they're associated findings?
Sure. So I mean, the systemic infection child would have exhibited signs and symptoms of infection, for example, fever. If it was pneumonia that was kind of spreading, then there would be a cough or difficulty breathing, things like that. If it was a urinary tract infection, there would have been burning on urination, for example. So the fact that there was a systemic infection and no medical care was sought kind of goes back to that whole denial of medical care.
Okay. There was what you labeled as stress-induced thymic involution. Could I ask what that is?
Sure. So normally, under normal physiologic conditions, the thymus, which is a gland in the chest, kind of neck area, that tends to shrink over time and turn into fat. It's where there is chronic physiologic stress, like an infection or malnutrition or things like that. The thymus tends to involute or shrink faster. And so microscopically, there are findings or characteristics that would support that.
Okay, that was going to be my next question. So the systemic infection could contribute to that condition, and malnutrition could contribute to that condition. Could the malnutrition contribute to that condition even in malnutrition over the course of a couple of days or a week?
It would probably be much longer than that. This would be a chronic, kind of thing, not necessarily an acute situation.
Okay. And thymic, what does that mean exactly? Is that like a gland?
Yeah, it's referring to the thymus, which is the gland.
Okay. In your report, there had been, you had a section on the gastrointestinal system. And in your report, you note that there were numerous tiny hemorrhages in internal organs. Is it fair to say your report does not suggest that this bleeding in the stomach was caused by blunt force trauma?
Yes, that's correct.
I guess so. There was bleeding in the stomach.
Are you referring to those? There's on page 7. There's
Yes.
Gastrocnemius exhibits normal folding architecture for multiple blanks, superficial or symmetric. Is that what you're referring to?
Yes, on page 7.
Yeah.
Could the bleeding, is that related to the systemic infection?
So those are not specific findings that you see in chronic stress situations, kind of like they're almost referred to as stress ulcers colloquially. So things like systemic infection, for example, is one cause. Burn victims tend to get them if they're in ICU for an extended period of time.
Okay. Okay, so you think it could be related to this overall systemic infection that was going on?
Either that or the chronic kind of underlying conditions. I don't remember if malnutrition was one of them, but things like that would be what you could expect to see them associated.
Would the hemorrhaging in the stomach, could that relate or could that contribute to the overall cause of death?
No, I think it's more of a chronic kind of finding that you would associate with chronic illness or chronic physiologic stress.
All right. There were a number of different bacteria that were found in the body. One of those, pronunciation, Moraxella catarrhalis. Take your word for it. What would be the cause of that bacteria in the child?
So oftentimes postmortem blood cultures are not very reliable because number one, the body contains bacteria to begin with, and as soon as that occurs, then the bacteria begin to proliferate, and then obviously the environment outside of the body is also full of bacteria, and so oftentimes postmortem cultures are not reliable, so you'll get a mix of different species. So I think in this case, the number of different species kind of suggests that there's more contamination effect.
So you think that this bacteria would be a contaminant in the child after the child had passed?
Either from the collection process or from the decomposition process.
Okay. But I'm guessing you guys like store bodies in a way that keeps them as preserved as possible, right? Like in cold temperatures.
Yes.
Would that reduce the chances that there be bacteria in the child or in a body?
I mean, ideally, yeah, there would, but if the bodies are determined before we get possession of the body, then that's a different story.
There was penicillium detected in the lung. Do you have the same answer for why that would be in the lung, or is that a different explanation?
Let me see if there's anything in the lung that I noted microscopically. So I didn't see any inflammation in the lung, so microscopic, so that tells me that it's more than likely a contaminant.
Okay.
Meaning there was no infection of the lung.
Is it possible these things were not contaminants, that they could have been there beforehand?
They could have been there, especially if the body started to decompose. Could be, after death.
Could they be there before death?
Both of those don't typically, they're not respiratory flora, which is the normal type of microorganism population that you would expect to see in a living person. So my guess is that more than likely they're contaminated.
But is it possible that they could be in a human being prior to a human passing?
It's possible, but I would expect to see evidence of infection. I would expect to see inflammatory cells or an inflammatory response in the lungs, which I did not see.
Weren't there fluid in the lungs?
Yes.
And wasn't the fluid in the lungs part of the overall infection of the body?
Not necessarily. Fluid in the lungs can occur in many different scenarios.
But could the fluid in the lungs be a part of the infection of the body here?
I'm struggling to see how there could be a connection without there being inflammation in the lungs.
Okay. You noted that there was what I'm guessing is E. coli found in 2 different samples that you looked at. Which parts of the body do you know were those samples found in?
Which part of the body were they found in?
Yeah, and in your postmortem report, you noted that there's E. coli found in the body. Do you know where in the body that was found?
That was detected in blood. So took a sample of blood and ran it for microorganisms.
And what is E. coli exactly?
It is a bacteria or a species of bacteria that is typically found in the GI tract.
Is it something that could hurt a child?
Define hurt.
Is it something that could have a negative impact on their health?
If the E. coli were to get into, for example, the urine or go up the urinary tract and cause a urinary tract infection and infection of the kidneys, then yes, that's one potential way it can hurt the child.
In this E. coli, that's something that was in the body before the child passed?
No, I think these are contaminants because there's multiple organisms in the blood.
Do you have these multiple organisms in the blood of all your people that you do autopsies on?
We don't run cultures on everyone, so I wouldn't be able to answer that.
Okay, so you don't have a baseline to determine whether these types of microorganisms and bacteria would be in all of your autopsies?
No, but generally the understanding is if there are multiple species affected, it's likely to be a contaminant, or they're likely to be contaminants. If there was one, that's more likely to be a true infection.
You noted that there was urine in the body that was brown, right?
Yes.
What does that communicate to you? What can you infer from that?
Well, brown and cloudy to me indicates that there was an infection of the bladder or the kidneys.
So is it possible because there was an infection of the bladder and kidneys that there was E. coli in the bladder and kidneys?
Yeah, in the bladder and kidneys is possible. But I don't have a urine cultures.
Where would a body get E. coli from outside of the autopsy process? Is that from food?
Fecal matter.
Fecal matter? Like coming into contact with fecal matter?
So the proximity of the fecal matter to the urethra, the female urethra especially, if hygiene is not optimal, then you can introduce bacteria into the urinary tract.
What if a person had, because Lariah had sores on her butt, right? And what if fecal matter came into contact with the sores on her butt? Is that how E. coli could spread into the body?
If they're open bleeding wounds, then there's a chance that you can get E. coli into the bloodstream here.
Okay. And you sat in on LaPortia's interview. Do you recall the part of the interview where she said that she believed that there was some poor hygiene because the child had been sitting on a toilet with poop on it?
I don't remember that specific part.
Okay, despite not remembering it, it's fair to say that, let's say, that situation was presented, then E. coli could spread into the body that way.
Well, like I said, it would have to go through the urinary tract. Or, as you mentioned, if there's an open wound that's, you know, in the skin, like there's a break in the skin, for example.
In the urinary tract, you know, it's close to the buttocks, right? Lariah presented to your office with a soiled diaper. Is having a soiled diaper for too long with fecal matter in it, that could get in the urinary tract, right? All right. There was an excess of fluid in the abdominal cavity. That's a peritoneal effusion. What is the significance of that finding?
So it's kind of a soft finding or not specific finding that we see in infection versus systemic infections. I mean, it can be seen in other causes too, or other, but in this context, it would be systemic infection.
And could that negatively impact a child's health?
Individually or on its own, I'm not really sure how it would look, but as an reality of it, it's actually good. Have one additional finding.
Well, if the fluid contains parts of the infection, it's in the abdominal cavity. I mean, that wouldn't be, you know, something that has no impact on a child, right?
And not necessarily, I mean, not all fluid is infected fluid. It's still be sterile.
Was this fluid infected?
We didn't culture that fluid.
So we don't know for certain whether that fluid was infected or not.
Right.
Could that fluid be from a lack of urination from the child? Okay. How would the fluid get there from wherever it comes from?
Second, sorry.
How would the fluid build up there?
Have to come through the vasculature, it would leak out through the vasculature. And
What's that mean?
what's that mean?
Yeah, you said from the vasculature.
Right, so that's where the fluid. So, I mean, there's fluid in your vessels, right? So there's different types of fluids and components in the blood and in the plasma. And so when you have systemic infections or other sort of conditions like liver cirrhosis, some of that material gets pulled out of the vessels and into the open spaces or into the tissues as well.
Do you know how that would have happened here?
There's a complex physiologic explanation for it, yes, but again, the point is that it's in relation to this systemic infection.
So the systemic infection, it really has a lot of impact on a lot of different areas.
Well, I mean, it's systemic, so it affects a number of different areas and tissues and systems.
All these things together with the systemic infection, with the different fluids, that has no contribution to the cause of death for the child?
Cause of death, like I mentioned, is the blood head trauma.
Well, do you think it could have weakened the body to the point where it couldn't kind of deal with trauma in a normal manner?
No, I don't think so. I think the blood head trauma would have either made her unconscious or comatose, or so I don't think having a systemic infection would have necessarily have any sort of relation to that.
Well, would it weaken the body is what I'm saying. I think you said that systemic infection could cause noticeable symptoms, right? Like fever. What else kind of symptoms could it cause?
It depends where the source of the infection is. So like I said, if it's in the urine or in the bladder, burning in the, upon urination, if it's in the lungs, difficulty breathing, shortness of breath, those kinds of things.
So it could affect a lot of different areas. Would the systemic infection be impacted by, would it impact a child's ability to use the bathroom?
When you say use,
Like, would it constipate a child? Would it make it harder to urinate?
constipation, I don't think would have any sort of bearing or relation. But as I mentioned, if it is a bladder infection, it would make it painful or burning, or there would be burning or pain upon urination.
Did you hear in LaPorche's interview her attempts at potty training?
I don't remember if it was an interview or if it was before or after, but I believe there was mention of potty training, yes.
And there was difficulties by the child to use the restroom?
Yes,
Do you think that could have been because of what's going on here?
it's possible.
There was also, you wrote approximately 50 milliliters of brown fluid in the left thoracic cavity. Is that different than what we just spoke about with the pleural effusion or the peritoneal effusion?
So
That's something different?
it's different body cavity, but it's again pretty much related to that whole process.
Okay. You write in your autopsy that, or your postmortem report, and what I'm going to ask you about is toxicological findings. You wrote that based on the circumstances known at this time, reported clinical history and collective postmortem neuropathological, histological, and toxicological findings, it is my opinion that the cause of death in this individual resulted from blunt force trauma. You stated earlier that in the toxicological findings, there was no drugs, alcohol, that kind of thing, right?
Let me just report insertion on page 9. Yes.
But you have this clinical history, and at the bottom of clinical history, it reads, reviewed medical records indicate intrauterine maternal substance use, including marijuana. Like what does that have to do with your bottom line findings here?
Nothing.
Okay, so
That I reviewed medical records and history that I came across.
why do you include that in the autopsy if there's a finding of marijuana that has no relation to your final opinion?
Sorry, one more time.
Like why do you include that in there then? Just to like show that you reviewed it?
I think it's significant in that it's part of the history. Even though she doesn't have a clinical history or medical history, that was the only kind of significant one that I can find in the review records.
Okay. In the clinical history, right, according to the decedent's mother, the decedent allegedly fell down half a flight of stairs, approximately 6 steps, approximately 1 week prior to her death. That's a statement that you gleaned from her interview with the police that you watched?
I don't remember if it was from the interview, but it was from some police report, whether it was a summary of that interview or whether it was subsequent, I can't recall.
All right. And you had testified previously that a fall downstairs could cause a subdural hemorrhage.
But unlikely, especially if it's that few steps.
Well, 6 steps. Are you saying that's a few? Do you know how high the steps were? Well, what if they were 10-inch height steps? That'd be 60 inches, right?
Yes, but each fall would be 10 inches. There wouldn't be a fall from 60 inches down to the floor.
Well, how do you know though? You didn't run any experiments to see if these were possibilities, right?
That's correct.
You heard everything that Miss Murray stated to the police when you watched the interview, right? You listened carefully to what Miss Murray said when she was interviewed by police, right? And I think you read the police reports otherwise. In addition? Yes.
Yes.
There's nothing in the postmortem examination report which says that Miss Murray stated that, she caused a blunt force trauma to the head, right?
Yeah.
There's nothing in your postmortem report that specifically says Miss Murray engaged in physical abuse towards the Raya. You have the manner of death here listed as homicide, right? But you also do list her statement that according to the mother that the child fell down the stairs. if the child fell down the stairs and was hurt that way, that would be inconsistent with homicide being the cause of death.
Not exactly, because there's the element of medical involvement.
Okay.
This child would have exhibited symptoms. This child may have been comatose. Certainly, if someone were to witness or even not witness a child fall down the stairs, but if it's assume that a fall down the stairs occurred, then reasonably, I think medical care would have or should have been sought.
So I take it from your testimony that a subdural hemorrhage on its own wasn't enough to cause death. It's being coupled with lack of medical care that.
No, I mean, it wasn't just subdural. There were also lacerations and tears in the brain.
Well, let me just ask a question though. So take the lacerations, the tears, the subdural hemorrhages, whatever medical terminology that it's there. Is it fair to say, based on what you're telling me right now, that that's not enough? It's coupled with the lack of medical care following it that was the cause of death.
I think the best way to look at it is that it's a totality of everything, right? So had I not had concerns of medical neglect, if this was an adult and all I had were the tears in the brain and the subdural, that would have been enough for me. But this child is dependent on another individual for their care and their well-being. It's definitely factor.
So there's not one without the other for a child then for you.
Sure, I understand.
Like you said, it's a totality of circumstances. So it's both together that was the cause of death. It's not just the injury to the head. It's the lack of medical care too.
In this case.
Okay. Okay. Thank you. Your Honor, I have no more questions. Thank you, Doctor. Appreciate it.
Any redirect?
Just briefly, Your Honor.
A couple things that I wanted to flesh out. I just wanted to go back to on your cross-examination. We talked about some of the bacteria that was found within.
Yeah.
Of all the bacteria, whether it was there prior to death or a contamination issue after the death, would any of that have caused the brain bleeds?
No.
Okay, or the tears or lacerations to the, okay. I want to make sure I correct this. Lariah came from the scene where she was found, her home, to the hospital and then to U of M, correct?
I believe that was the sequence, yes.
And I'm sorry, when I say U of M, I'm talking about your lab. Okay. You were asked on cross-examination about a diaper. Isn't it true she was wearing underwear, soiled underwear?
That's correct.
Okay. Okay. Couple other things that I want to talk to you about. In your testimony, you referred to, well, let me go back to the interview. Testified earlier on your cross-examination about your involvement with the interview. Is there anything, you've had now a little bit of time to reflect, is there anything that you think that you might need to correct about, your involvement in that interview process?
So, yes. So I initially, when I was asked, I believe it was on Ross, what kind of questions or discuss or what topics were discussed. And the only thing I could remember at the time was related to the head trauma and the findings in the head. Reflecting back, I do believe that there were also discussions about the body temperature and the length of time between when EMS or first responders arrived and the time of death. I believe those were also topics that were brought up during the interview that I think recall during the process.
Okay. And do you remember, did you take any notes or would you have taken any notes as a part of sitting in on that interview process? Okay. Is there anything when you were there listening to mom that gave you the aha, that explains everything? Okay. You also testified that this case for you was complicated. Can you kind of elaborate what made it about Lariah? What made this case complicated for you?
I mean, the circumstances, this is a 2-year-old who's mobile or presumably mobile with a developmental dysfunction or delay. So, of course, having to rule that out as well, this is The story being that she fell downstairs, and that had to be taken seriously and evaluated in the context of the findings, both at autopsy and investigation. And what made it complex, or just one facet of it, was that had she been a 6-month-old or a 9-month-old who was not mobile, it would have been a lot more straightforward in terms of, potential causes or potential ways that trauma to the head could have occurred.
Towards the end of the questionings on cross, we talked about the totality of the injuries and the denial of care plus the brain bleeds. And I just want to separate something out. If, hypothetically speaking, if somebody came and punched Lariah in the head or shook her or did some damage, does the denial of care, that in of alone could that have been a source of the brain bleeds? Like direct blunt force trauma.
Yes.
Okay. And with that, at that point in time, it would have been homicide if she would have died from those, regardless of the denial of care.
Yes.
Okay. Either way, is it your testimony that whether it was some kind of maybe self-propelled injury or some kind of intentional infliction injury, there would have been behavioral changes in Lariah?
Yes.
Okay. And that's what you're getting at. Somebody should have picked up on that. A caregiver should have picked up on that. Okay. Just a moment, Your Honor.
Yes, sir.
I don't have any other questions.
Any follow-up?
No, thank you.
All right. Thank you, sir. You can step down. Thank you. Any additional witnesses?
I don't have any additional. Thank you. We've already taken the testimony of several other witnesses.
Pardon?
Taking the testimony of several.
I'm aware of that. Any?
No witnesses.
All right. Do I have a motion?
At this point in time, I'm going to motion the defendant, motion to court to bind the defendant over on the charges contained in the complaint.
Respond.
Your Honor, we submit to the court that the proofs just aren't there for showing that Ms. Murray engaged in a knowing and intentional act that resulted in the injury. A lot of what's here is opinion, it's speculation, it's fill in the blank. What's missing is probable cause with proofs that there was a knowing and intentional act, which is required for the first degree child abuse. Denial of medical care itself doesn't qualify for first degree. It's not a knowing and intentional act.
Well, when you're referring to an act, that would include an omission.
I don't think so for first degree child abuse, Your Honor. I think it certainly hits a different child abuse degree. I just don't think it gets us to number one here.
All right.
And I know Mr. Emmons cleaned up some things at the end of redirect, but the doctor did spend a lot of time talking about it, a totality of circumstances, a combination of head trauma and lack of medical care coupled together with this particular patient that was the cause of death. And if the denial of medical care is not something in and of itself that could qualify for first degree child abuse, then I don't think we can say that the cause of death necessarily was a head trauma itself. But I've obviously already, our original position is that the proofs, as Detective Sinks acknowledged, there's no admissions, there's no eyewitnesses. There's nothing that we can say or point to says this was the knowing and intentional act that resulted in the injury, Your Honor. At the end of the day, being honest, I can concede that there's other degrees of child abuse within this fact pattern here. That's there, Your Honor, but first degree is not present, Your Honor. And based on the testimony, I don't think first degree child abuse resulted in death itself, Your Honor. So I'm asking the court to not bind over on first degree child abuse. And of course, the other charge doesn't go with it if that's not bound over.
Mr. Emmons.
Just a second, Your Honor.
I understand the argument being made, and I'm sorry, I'm sitting down just so I can check the charges in the complaint, just so I can double check. I'm not trying to disrespect the court. Okay. Is she charged with degrees or is she charged with open murder?
She is charged with felony murder.
Felony murder. Okay. And so the felony murder provision has to be one of CSC, or not CSC, of child abuse in the first degree, which is an intentional action. What we have here is the testimony from the good doctor that the cause of death was the brain bleeds. Those are what eventually were to lead to Lariah's death. It is notable that there are other infections that are going on within the body, but what directly resulted in the death is the bleeding on the brain. So the question is, how did she get the bleeding on the brain? That's what the question is. If it's first degree, right? If it's an intentional infliction, i.e., mom is the one that hit her, mom caused that abuse. That cause, as Dr. Tajian stated, that would be a source of those injuries if somebody were to do it. And that would be child abuse first degree. That would be the predicate felony for the first degree murder. That being the case, what we also saw and what the court has in its possession are the pictures and the notable amounts of physical injury in and throughout the rest of Lariah's body. You have the statements made to mom, to Detective Sinks about prior engagement in physical discipline or abuse of the child, which suggests, when we look at the entire picture, that this was a mother who was abusing her child, who took it too far. And then when it went too far, the cops arrive. She's actively trying to perform CPR. She's misrepresenting the actual time of death. When Officer Sims, the deputy Farmer went there, they were able to feel her whole body through their nitrile gloves. That being the case, that's something happened. She did it, and she didn't do it. Bigger picture, we have a long history of denial.
Well, what do I have that says she did it?
I'm sorry.
You say something happened and
Well,
she did it. What do I have that says that?
So we had Dr. Tajian saying that there was the brain bleeds that was caused by some kind of external factor. And then her statement to Detective Sinks was that she had been using physical discipline on the child.
In and about the head? I don't think that was the testimony I have.
No, not specifically about the head.
Well, then how do the people connect up? Let's say if she spanked her and had that type of corporal punishment or other type of corporal punishment, how do the people tie that up to brain lesions?
If it was spanking, I don't. What I'm saying is that there was an external force, a blunt force trauma to her head that resulted in a brain bleed.
Okay, I understand that. But what evidence, because when I'm looking at this, what evidence do I have that the defendant did something that would have caused that injury?
She's the only caregiver for Lariah at this point in time. As she explained to the deputies, she was the only one taking care of the child. And so this isn't something had to have caused it. And that's when we get into the idea that falling off the stairs is an unlikely source of the injury. So it becomes less and less accidental. It can't be accidental. So if it's not accidental, then somebody had to have caused it.
Okay, but how do I get to this defendant being the one that knowingly would have caused that?
Just a second, Your Honor. So, right, and so we go back to Detective Singh's statements, right? She noted, I think to Deputy Farmer at the hospital and then to Detective Singh, that she knew that something had happened, right? And that there was this noticeable change in behavior. And then she didn't do anything about that. And so it's that inference that when she didn't do anything, that inference of guilt that she had done something to her that caused the brain bleed.
Say that again. I mean, isn't that, I mean, but where do I make that connection? Because it seems to me that if I know something or the defendant knows something has happened and doesn't do anything, that is what I was speaking with Mr. Bernstein about, the omission, as opposed to some overt act on her. Unless you're claiming that upon noticing that her failure to get medical care for the child is an act that causes the physical harm to the child. But I don't think that was said either. And I think that if that's the case, that takes me to a different degree of child abuse, doesn't it?
I'm sorry. I got you until I didn't. If you could just repeat that one more time for me.
The whole thing.
I know
You're arguing that something happened.
Right.
And that then you weave into that the defendant did not get care for the child.
Correct.
I don't think you're arguing that her failure to get care amounts to the first degree.
No, thank you.
What you're arguing, it seems to me, is that her failure to get care for her child, the court is supposed to use that as some type of evidence that she intentionally did something.
Yes, I think that's a reasonable inference to make. Just as if we use the flight instruction for somebody who flees from the scene, right? Her failure to act when she first started noticing these symptoms, right? Because she knows, I think
Well, but hold it. What? I don't know how I get there. Because I don't think that what the one thing you're saying means that next thing. I mean, because you're saying her failure to act somehow tells me she did something. That's a leap. I mean, it's a huge leap. I mean, and it's equally as plausible that something could have happened to the child. She recognizes that something's going on with the child, but then doesn't do anything. And isn't that really what we're saying? Because we don't know what happened to the child.
And what I believe the evidence has demonstrated is that the defendant was the caregiver.
Give me every piece of evidence that you believe you've elicited that tells me that this defendant caused the blunt force trauma to the head.
I mean, I can see there's no statements or anything that suggests that.
That's not what I'm saying, Mr. Evans. Give me every piece of evidence by which you want this court to draw the conclusion that the defendant knowingly and intentionally committed blunt force trauma to this child's head?
All right, so if I start with Dr. Taj's examination, he finds the brain bleeds and the brain lesions in the brain. And that has an external source. That's what he, in his opinion.
I understand that, Mr. Evans. I'm asking a very specific question. You're asking me to somehow and or another draw the conclusion that this defendant did some act that caused those injuries. I don't think it's disputed that the injuries are there.
Right.
The question becomes, what caused it?
Correct. I agree with you. And
So I'm asking then, give me each piece of evidence that people have that says this defendant caused it.
it's a series of inferences based on what happens after the fact, because we don't know what happened because mom didn't do anything.
Then give me your inferences. Give me the facts and what inferences you're drawing from it. Because what I'm getting is that you're drawing inferences by really what would be an omission to act.
And I'm saying that the inference of physical abuse comes from the phone call to 911, right? The officers respond. Mom says that she had only just died. But Trent Sims and Alex Farmer walk in there and notice that Lariah is cold to the touch. Dr. Tajin says she had been there for hours. She must have been there for hours. When the officers arrived.
How, Mr. Emmons, I have what I think are copious notes regarding the evidence and what was testified to. That's not my question. My question, simply put, is tell me something that tells me she did it.
Because she's the only caregiver.
But there are other people there.
After the fact, they were.
After the fact?
Well, you're right.
I know, but there are other people there.
Not at the time that Dr. Tajin says the child actually passed away. Other than the other children. There's no other adult at that time. The injury had to have occurred a couple of days prior to that.
How do I know that?
Dr. Tajin testified that when we got into the details of the forensics, when he was talking about the amount of blood that he found in the skull.
Okay. But doesn't that make your case worse?
But then again, she's the only adult caregiver through that period of time.
Okay, but Mr. Emmons, you're asking me to say this person knowingly did something that is something different than an omission to act on behalf of your child. And initially, you're saying, when you talked about the 2 hours, where I thought you were going was there's a very small window at which she being the defendant, would have been the only one that would have been caring for the child. Now saying that it's 2 days, the reality is I don't know who's around that child, do I? Or what evidence do I have as to who's around the child?
Again, I'm trying to draw a distinction here between what we're using the omissions for, right? And it's the omissions to act versus I'm sorry, and let me just rephrase it. It's active misrepresentations about what had happened. I believe, if I recall correctly, that in her statement, Detective Sings testified to was that she was the only caregiver for Lariah for a period of time. Deputy Farmer had testified that I believe that he also said that she was the only caregiver when she noticed that she wasn't eating for about a week, right? And we know that I believe that she told Detective.
But the eating and drinking is not what killed the child.
You're right. You're right. But I'm saying I'm trying to bring it in that she's the only adult caregiver for this period of time that we're concerned about. With that being the case, right? She actively misrepresented what had happened because she's scared of the abuse about them discovering the physical abuse. So that's why she's not involving the police. That's why she's not taking Lariah to the hospital. That's why it looks as if she's performing CPR when the officers arrive on a child who's been for several hours ahead. And so the act of lies have to be the evidence that she had engaged in an intentional act, or it's not. And then we talk about second degree, which then gets to the appropriate purpose for the omission.
So what I just heard is you are claiming that the omissions are the act.
I'm sorry, just for second degree? For second degree?
No, I'm saying
I'm saying the not going to the hospital, telling the lies to the police is an attempt to cover up the physical abuse.
okay. So let's assume, for the sake of argument, that you're correct in that. Even if I make that assumption, what do I have that says the defendant did the abuse that caused the death of this child? And by that, what I mean is, if I open up the time window, if somebody else caused blunt force trauma to this child's head, another adult, another child, whatever, this defendant, the mother, fails to act, and doesn't, whatever her motivations are. Let's say she's protecting one of her children. Let's say she's protecting one of the other adults that comes by. Let's say she's doing all of those things. Whatever her motivation is, and fails to take the child to get medical care.
Second degree.
Yeah, and it's not first degree. That's your argument.
And I'm saying,
Because I don't tell me something that says she did it.
because why else would she lie about what had happened?
As I just said, it could be to protect somebody else. It could be to protect a child. Why else would she do it? Who knows? But it's not her burden, nor the burden here, to say why else would she. Your burden is you have to show me that she did, at least to some level. I mean, you're asking me to bind her over and find probable cause based upon a negative.
I understand that. But I think that Dr. Tajine's testimony suggests that The injury really did happen.
Nobody's disputing that the injury happened. I'm saying the negative is we don't have evidence to show who did it. So based upon how she's acting, she had to do it. That's really what you're saying to me. And I don't think that rises to the level of probable cause. Unless I'm giving you every opportunity, tell me something different.
I understand, Your Honor. I understand. I don't know that there's anything that I can say in addition to what I've already said.
Don't understand anything additional.
No, Your Honor.
I'm sorry.
Yes.
You want me to,
Go ahead.
me to argue the second degree part? Or?
Yes, go ahead.
So I think that at that point in time, there is this affirmative testimony about the omission, the denial of care that he testified to. And I think it's clear that she was in a position to have done something. She acknowledged that there was a problem and that this was a child who needed it, who needed that care, but didn't get it. In that those actions, seeing the decomposition happen as required under the element, created a very high risk of death or great bodily harm. And obviously that happened. If you understand.
Urchin, did you want to make any argument as to second degree? Sure.
I'm just looking at the statute.
If you want to see it on the computer, Sam.
I found it. Okay. Good. No, Your Honor. Leave it in the court's discretion.
All right. The court has heard the testimony, took notes, and let me just say at the outset, that what happened to this child is indeed disturbing. And I think that tragic would be an understatement. As described by the medical examiner and the officers that arrived on scene. No child, but certainly no child who may not have an ability to fully appreciate or understand should have had to suffer in this way. It's the only way that you can describe it is a suffering that, as I was listening to the deputies who arrive at various scenes, seeing that little one's body, how even all this time period later, it still shook them up. But irrespective of how tragic something is, this court is duty bound to follow the law. This court doesn't bind people over to stand trial based upon the emotion that's involved in any case, because I will tell you that seeing the photos listening to the description, listening to the medical examiner describe and Detective Sinks describe what this child may have gone through. If this court were to solely rule on emotion, I'd find the defendant over in a minute to stand trial for murder. But that's not how our law works. What would have to be established for this defendant to face murder is the predicate charge of child abuse in the first degree, which requires basically an overt act, something other than omission, something other than that. And it has to be shown that this defendant, while having care or custody of that child, did that act. In this case, people have not met their burden of showing that predicate offense of child abuse in the first degree. And having not shown that, count one, the felony murder, which is predicated on the child abuse in the first degree, also must fail. And so the court will decline to bind the defendant over on the homicide charge as well as the child abuse first degree. Defendant will be bound over to stand trial on child abuse in the second degree. In this case, because that the court does believe the people have established.
Yeah, I'm sorry, are you also binding over on homicide in the second degree?
You're doing homicide second degree?
I'm sorry, I thought I articulated that. That's the death plus the omission creating a great risk of bodily harm would be the charge.
The death plus the omission.
Right, that Mariah died and that the defendant knowingly created a circumstance that created a great
So you're arguing second degree murder?
correct. It's that the defendant caused the death and that the defendant did.
You did not make that clear. I thought you were arguing child abuse in the second degree, but you're arguing second degree murder.
Correct. I'm sorry, Your Honor.
Mr. Bernstein, I don't know if you understood that or not. I did not.
I did not, Your Honor. Right? That was not clear to me.
Okay.
My turn for arguments.
Pardon?
Was the court looking for me to?
Well, did you have a response to the request for the second degree murder? If you need a moment, I'll take a break and I'll come back and I'll hear your argument. I
could use a moment.
Okay, then no, that's fine. That's fine because I did not understand it and certainly you didn't, and I don't want you trying to respond off.
I apologize. I didn't mean to I wasn't trying to mislead the court.
All right. So court will stand in recess. Back on the record in the case of the People's State of Michigan versus Porche Murray. Mr. Bernstein.
I think, Your Honor, the court had given us right to review or whether the case met second degree murder or not. I did not realize that there was an argument for a find over on second degree murder during the argument, but giving it a chance to review it, I think that the prosecutor's argument does fail for the same reasons. Second degree murder, and looking at the jury instructions, is focused on an act by the defendant. And we still don't have an act by the defendant that would rise to the level of second degree murder. Part of the jury instructions, first, the defendant caused the death of the deceased. That is, that she died as a result of state act or alleged act causing death. There are several states of mind listed in the jury instructions as one or the other requirement for second degree murder, but all of those are centered around a likely result of his or her actions. And we still don't have the action causing death. I think it's still just an omission, to act. I don't want to argue against myself. I don't want to help the prosecutor's argument, but I think what they're really arguing is more of an involuntary manslaughter, failure to perform a legal duty, that seems to fit what is going on here, a gross negligence omission. But second degree murder, it fails for the same reason that first degree murder fails, that the act that would result in death or high likelihood of death is still missing, and absent that death, there can't be PC to bind over, Your Honor. So I'm asking that the second degree murder argument fail for bind over.
Mr. Evans.
Thank you, Your Honor. I understand the argument. So, I think appropriately, then officially for the record, I'd be asking, knowing that the court's not inclined to bind over on the counts 1 and 2 as charged, it would be added counts 3 for second degree murder, 4 for involuntary manslaughter, 5 for the child abuse second, and 6 for child abuse third, in the third degree. And the idea here is that the elements of second degree did cause a death by, and in this case, as Dr. Taj testified, the denial of medical care. Knowingly or created a very high risk of death or great bodily harm, knowing that the death or harm was a likely result. And I'm looking at a particular case here when we were talking about this during the break. And so I'm looking at People v. Portellos, 298 Mish App 431, which is a 2012 case. And it says here at about page 446, on the basis of the facts, reasonable jury could conclude that, and this is about a dead child case. She gets convicted of second degree murder and child abuse. Could conclude that Portellos intentionally smothered the baby Portellos so that Mary Portellos would not have the baby cry, would not hear the baby cry. A reasonable juror could alternatively conclude that the baby died, 1, because Portello failed to summon medical assistance, 2, from being wrapped tightly in a towel, and it goes on from there. But it's that 1, because Portello failed to summon medical assistance. That served as the basis, or alternatively a basis from which a jury could convict of second degree murder. And we have this very high risk of great bodily harm. We go back to, mom admits that there was some injury. She knows that the kid's not eating or drinking. She admits to the officers that she's watching her decompensate. That's not the word that she used, but that things are getting worse. And then that denial of medical care, right? It comes from that self-motivational point of view to try and protect herself. I think she said that it was that she wasn't, to Deputy Farmer, that she wasn't drinking or eating for a week. And then to Deputy Sings, I think she changed that to 2 or 3 days. Knowing, if this is happening, right, what would a parent do if your kid's not eating or drinking for 2 or 3 days or a week? You have to get medical care because you know that situation is not going to resolve itself. So from that, I do believe that there is sufficient evidence to bind the defendant over on the charge of second degree, and then involuntary manslaughter would be that the causation, that the doing the act, the denial of medical care was an act of gross negligence, that wanton disregard, that inaction was a wanton disregard for the child, for the care of the child. And correspondingly, the second degree child abuse and third degree child abuse, the omissions creating a likelihood of various states of harm. So for those reasons, Your Honor, I'm asking the defendant to bind the defendant over on those added counts.
So the act that you're predicating second degree is really the omission?
The denial of medical care. Is some substance the same as this Portello case when it says Portello's failed to summon medical assistance.
Mr. Merkin.
If you're looking at Portello there, that's a case involving a conviction for first degree child abuse. It sounds like there were facts alleged about smothering with a pillow. So I think we have an apples and oranges situation here, where in that case, there was a very affirmative act that was found to have taken place. And that's exactly what's missing here. And that's what my argument is that there's not an act. I think there is, acknowledge that there was an omission here, but now it's being labeled an act so that it can backdoor into second degree murder, but that doesn't change it from an omission, Your Honor. And so I think there's a sufficient distinguishing from this Portella case that involves a parent who did a recognized act that caused an injury, and that one of the theories of medical care seems to piggyback from that and is not a central theme of that case, Your Honor.
Mr. Emmons, don't I have the same issue with second degree, the act in and of itself?
And again,
I mean, the act has to cause the death. And what I have here, according to the medical examiner's report, is that the act is the act that causes the blunt force trauma.
or I think in this case, is Dr. Taj, when he referred to the totality with the contributing factor, the denial of medical factor. And so again, I point to the Portello's case. They said that a reasonable juror could conclude that Portello's intentionally smothered the baby, Portello, so that Mary Portello would not hear the baby cry. A reasonable juror could alternatively conclude that the baby died, one, because Portello's failed to summon medical attention. Yes, there were these arguments, but they're saying that would uphold the basis of the conviction, that alternative argument. However, the jury came to their conclusion. Here's a number of theories that they could have come to. Each one of those would have been good, because it says we conclude that sufficient evidence supports Portello's convictions of the first degree child abuse and second degree murder, because the reasonable juror could find that Portello intentionally took actions that caused baby death. Those actions with a wanton disregard of the risks.
But, and I haven't read that case, but doesn't it seem, just based on what's described, that the real issue becomes, in that case, I have an act, right? But then that the jury, and you have to help me, and maybe I need to go back and read that case, but I have an act of the smothering. And then the court is basically saying a juror could find, or a reasonable juror could find, that it was the act of the smothering itself, the act, or based upon that act, the failure to get medical care. Right?
Right.
But does that mean I'm still missing here the act? I mean, it seems to me that a fundamental distinction maybe between the facts in this case and that case are that I still don't have an act. So hypothetically in this case, and I'm not at all saying this is what occurred, if Miss Murray had taken an object and struck the child ultimately dies. Maybe weeks later, however much later. In that instance, certainly there is an act and then the conclusion as to what caused the death either was the actual striking or the failure to get medical care. That would seem to me to be similar to what counsel's describing as that case. What I don't, but, and I fear I run into the same problem that I did with the predicate to the felony murder. And that is that I think I need an act that I can attribute to this defendant other than an omission. Mr. Bernstein, that's your argument.
Yes, Your Honor.
I mean, Mr. Emmons, if you think I'm looking at that case that you cited as in the wrong way, tell me. But I mean,
it's a difficult case, right? Because they charged her with first degree murder, and the jury comes back second. And then they have to justify it, sort of. And that's why the Court of Appeals says, look, they affirm the conviction for second degree murder, and then they lay out, this is it, right? Either it was a smothering, or it was this failure to call for medical assistance. And so it's that term that piques my interest in the same sense that it's.
no, I think I hear you, but under either of those scenarios, whether it be for the first or second, I have an act. And then the determination is made. I have something that occurs that the defendant is responsible for, an act. And then at some point, isn't really the jury in that case either saying, because of that act, the jury could conclude it was the act itself that caused the death. So asphyxiation, I would imagine, under suffocation in this instance, right? And if the jury concludes that that is what caused the death, then at least if I equate it to this scenario, the jury also properly could have found that that's first degree or felony murder, right? Or what the jury could say is it wasn't that did it, it was the failure to obtain medical care, which then may knock that down to a second degree so that there's a basis upon which the jury could conclude second degree. And I think I'm running into the same problem. In either of those scenarios, I have some act on the defendant's part that does something.
So I'm just reading the case law.
No, I got you.
And so that case, the medical examiner determines that the child dies of asphyxia.
Okay.
Right. And so that obviously it didn't happen. That's not natural. It didn't naturally happen. Right.
Okay.
So they concluded, just like in this case, the
the injury to the brain just didn't naturally happen. But then the jury comes back with the second degree conviction. Court of Appeals, they just say that one of the possible paths there is this failure to summon medical assistance. So I don't see the words, like, I don't know that they don't ever tie that there was the action. They just say they could have found that maybe she failed to summon medical assistance.
So you would say that under that case, and again, I've not looked at it, and maybe I need to take a look at it, but that under that case, that had it been a total stranger that had come along and asphyxiated the child, that there still could have been a second degree murder.
Not for the mother. Right? Like,
Right, because
I want to make sure that we're,
no, that's what I'm getting at. And I think you might have answered my question, because doesn't that case potentially stand for the proposition, which we've been arguing before, that there's this act, right? That from that act, there are these possibilities of why the child died. But it's the defendant's act. But even if it's asphyxia, presumably the medical examiner came along, well, if they had gotten medical attention right away, this wouldn't have occurred, or the child could have been resuscitated, whatever. But on that, I have an act.
and that's where I look at the Portello's case, and it's if they're saying because for failed to summon medical assistance, it's that failure that they keep referencing. And it says a reasonable juror could alternatively conclude that the baby died, 1, because Portello's failed to summon medical assistance, 2, from being wrapped tightly in a towel, or 3, from being placed in a garbage bag. And it's that or 3. So you have 3 of those 4 possibilities that they laid out are possible ways that they could have convicted. And one of those is the failure to summon medical assistance. And so like that to me would not be the act. It would be the inact or inaction.
I do, folks, is this. I want to read, you said that was 298.
Of course, Mr. Childers gave me a new case.
298, Mishap 431.
431. And you said it was on about page 446. I wouldn't make any. Well, I got you. No, it does make sense. It does. Gotcha.
So it gets overruled. It's overruled authority, but for some OV sentencing purposes is the reason that it gets overruled.
Okay. But not, okay, I got you.
I don't see for that proposition of law, it gets overruled, but for some sentencing discrepancy.
Gotcha. All right. What I'm going to do is I want to look at that case and give counsel at least an opportunity to present to the court any other information that they may have regarding that would substantiate a second degree murder.
Would you say counsel, are you asking both of us to read
Either one, anybody that might be referred to as counsel. I would need that by close of business tomorrow, however, so I can go through it, because I'm going to set this for Thursday for my decision.
Okay. All right. If I could ask for anything, I do have my docket tomorrow. So I mean, I'll work on it tonight, and fair enough.
You have a docket?
When did we come back?
Thursday at 2. What is Thursday, the 30th?
Yes.
So the 30th, May 30th, 2024. I'll set that at 2 p.m. for a decision. Bond will continue. Thank you.